claims, the expectation is that there's going to be some consequence for it. Doesn't mean a zero tolerance, meaning in the sense that every breach of a health and safety standard is a capital offense from the perspective of their employment. It just means that it's going to be addressed in some way. It could be some sort of written warning, could be a suspension. Whatever your employment contracts or workplace organization would allow to happen is what the courts are going to expect to see. And ultimately, and though it's not here, my ultimate rule on due diligence is document, document, document. If you take these positive steps, write them down. If your supervisors are on site inspecting for compliance, have them keep a journal, have them take notes, so that if they are called upon, and if the organization is called upon to demonstrate what it did, you do have this ongoing record of what steps were taken, both individually and at a corporate level, because really what's good for the goose is good for the gander when it comes to supervisory monitoring. The supervisory monitoring will help the organization from a due diligence perspective. It will also help the individual supervisor, because what the ministry is doing now, and what has happened since about 2004 or so, is that individual liability is far more likely a prospect than it was a number of years ago. Is the ministry is taking far more steps to enforce individually. The number of charges that we are seeing against individuals is increasing, and it is very difficult these days to negotiate a resolution whereby perhaps the corporate defendant would admit responsibility and pay a fine and have all charges dropped against the individuals. That's less likely to happen now. The prosecutors are looking for individual deterrence. Mike already talked about the maximum penalties, so I'm not going to go into those other than to say when you're looking at what kind of fine or penalty may be imposed in any particular circumstance, there are a number of criteria that are taken into account. It's the size of the organization involved, it's the extent of harm, because if a worker is hurt or if there's no injury, that's clearly going to be treated differently than if someone is killed on the job site. It's going to look at the need to enforce regulatory standards by deterrence, and what that means is they will look at your organization to say, is this an organization that needs a message, meaning that it needs a higher penalty than might otherwise be imposed in the circumstances. And they will look at, from that perspective, what's your history with the ministry in terms of the orders that have been issued previously? Do you have any prior convictions under the Occupational Health and Safety Act? They will also look then generally to say, does the industry need a message? And if there have been very few prosecutions in the photovoltaic solar industry to date, then it may mean that the first one or two that come up might become sort of messages to the industry if the ministry draws the conclusion that perhaps the industry generally needs a reminder that health and safety standards need to be met. The final bullet that I have there is about the Dean panel, and that was the expert advisory panel that was struck following a number of high-profile tragedies that largely occurred in the construction sector. And they came out with a number of recommendations, many of which are on their way to implementation and have been legislated by Bill 160. The one that I put there is one that will not find its way into law. In one of the recommendations from the Dean panel, it said there ought to be more serious and tough enforcement for serious and willful violations of the Occupational Health and Safety Act. As a former prosecutor, what I can say is that, well, I always thought that was the case, that if you had a gross or willful breach, you would take a more strident or forward-leaning position on settlement or on the penalty you would ask for. However, what I think the upshot of this is I think that's going to make it more likely now that prosecutors are going to seek higher fines. Because if the ministry can show that it's collecting more money year over year, they can say, well, we're seeking higher fines. And if you look at the ministry's website, there are enforcement statistics published there. They are publishing how much money is being collected or at least awarded in the way of fines. If they can show an uptick there, it seems to me that from a political perspective, it allows them to show that there has in fact been, that Dean panel recommendation has been heeded by prosecutors because they are seeking more serious and tough enforcement. So I see that as meaning that the tariffs for penalties are likely going to be on the upswing rather than something that's is going to plateau. That sort of is in almost a whirlwind manner, the remarks that I have. I do have a couple of handouts if you are interested. What I've got is our firm has put together a couple of things that are yours to take if you wish them. One is about key due diligence steps. It is the long-winded version of what I spoke very rapidly about this morning. That if you wanted it, it goes through a number of, or each and every one of those bulleted items that I had with some detail. The other is, should you have a workplace incident, here's our plan for how you should respond to it. It's not a detailed plan, it's one that, in the sense that it provides you an exact roadmap, but it does lay out for you the kinds of issues you should think about and how you might respond to that to best protect the interests of your organization and the individuals that you work for. I think I've probably been slightly long. I will take any questions you do have, if you do, and be happy to answer them. Yeah.
Any quick questions?
I was just wondering about the fines. Are those fines that the owner of the business has to pay? Like the corporation, 500,000, 25,000 for the individual defendant? Or it's not going to be passed on to the employee who's not wearing a hard hat or something? It's going to be the owner of the business, right, who will be fined?
Whoever is charged becomes legally responsible for paying it. So if the organization is charged, if it's ABC Company Inc. that's charged and convicted because Joe Smith was not wearing his hard hat, then ABC Company Inc. is the one that's legally responsible to pay the fine. I don't think there's anything in law that says they could recover that from the employee. So it's like it generally is the corporation. If an individual that's employed by the corporation is charged and convicted, it's really a matter of a negotiation between that individual and their employer as to whether the employer will pay the penalty. I've got clients where they do that, I've got clients where they don't.
Okay.